ethical challenges in private practice, and we're going to be using some clips from some movies as to sort of help format or sort of focus the discussion, and then we're going to talk a little more based on our personal experiences. So what do? I hit?
Well, actually, you won't be touching this. It'll just use this as a mouse every time you want to clip.
Okay.
I think once the clip finishes, it's going to always go back to this menu,
Okay.
and then you'll just keep selecting it, next
Okay.
clip and the next one.
Okay. A little by way of background. Okay. Professor Coleman and I were actually in practice in Washington, D.C. at about the same time. We overlapped. He was at a large Washington, D.C. Based law firm. I was at the Washington office of a large New York City-based law firm. So our practices did not really encompass the full spectrum of issues you see in private practice, where you've got lawyers, solo practitioners, small firm attorneys, and you also have large firm attorneys. But a lot of the issues may be the same in kind, they just differ in scale. And so we're going to look at a couple of issues. The first issue we're going to look at is drawn from a civil action. And it's this question of attorney fees and the payment to an attorney, and how the client's view and the attorney's view of litigation and the role of fees may be very, very different.
These are the Canes, the Toomeys, the Zonas, the Robins, and the Afieros. Now, I want to be clear. I'm not interested in money. None of us are. That's not why we're doing this. What we want is to know what happened. And we want an apology.
From who?
From whoever did this. I want somebody to come to my house, knock on the door, and say, we're responsible. We did this. We didn't mean it, but we did it, and we're sorry.
But who is that?
Well, we don't know.
Mrs. Anderson, our firm is very small, 3 attorneys, that's it. Which means that we can only take on so many cases at once. And we have to be very careful about the ones we do, because frankly, we can't afford to lose. Our clients pay nothing, we pay everything, and we only get paid back if we win or settle.
I know that.
But no, you want an apology. And there's nothing more I'd like to do than to get you that apology. But from who? Who is going to apologize to you and pay me? There has to be a defendant and one with very deep pockets. This is not an inexpensive case to try.
There's an old tannery out there.
A tannery.
And some other small factories.
I really wish I could help you, but I can't. I'm sorry.
Maybe you could go out there for just a few minutes to the river, to the wells, and take a look.
For what? What would that accomplish? I do hope you find someone, and I am sorry.
Let's get this junk out of here.
I've been informed that a settlement agreement has been reached. As a condition of this agreement, the exact terms shall remain private among the parties involved. I want to thank you for your service.
Our contingency fee, as you know, as you agreed to, as is customary, is 40%. But Jan suggested, and we all agreed, to reduce that to 28%, or $2.2 million. Our expenses, what we actually paid out trying this case, comes to $3.5 million. Now, subtracting that and the 28% in fees from the $8 million we got from Grace and dividing it equally among you comes out to $375,000 per family.
And they're gonna clean the place up.
No.
When you first came out here, Mr. Schlickman, when we first spoke, I told you I wasn't interested in money.
Here it comes.
What I wanted was an apology from someone for what they did to my son. And you said money is the apology. That's how they apologize, with their checkbooks. Would you call this an apology?
No. The only meaningful apology you're going to get is from me. I'm sorry.
I'm afraid that isn't meaningful.
Mrs. Anderson, you're looking at 4 guys who are broke. We lost everything trying this case.
How can you even begin to compare what you've lost to what we've lost?
Okay, that sort of presents the issue. The rules speak of attorney's fees being justified, being reasonable. 40% as a contingent fee is pretty high. I say that as a defense lawyer who opposed plaintiff's counsel. So when they reduce it to 28%, that's closer to the 33%. But what's interesting in this clip is the divergence of views between the client and the attorney about the purposes of the litigation and the role of money in satisfying their claims.
This is, we were both defense lawyers in litigation like this. I mean, I'm not talking about environmental litigation, but in litigation involving corporate defendants. We generally represented defendants in such litigation, although I did represent some plaintiffs in pro bono cases where we represented class actions. And this is a problem both for the plaintiff's attorney and for the defense attorney. For the plaintiff's attorney, there is always the possibility that their interests will diverge at some point. You saw the families, they start out, they say it's not about money, it's about something else. And then when you get to the end of the litigation, which usually results in a settlement, it then becomes much more about money than about whatever the other thing was. And that creates a problem for the plaintiff's attorney, which has to be managed. On the defense side, what often happens is that the defense will try to take advantage of that potential tension by offering a settlement that basically says, I'm going to give you a lump sum. You decide, you and your clients decide how to divide it. And that's a very difficult position for the lawyers, and that's what you saw here, where they agreed to reduce their contingency fee in light of, a disappointing settlement for the entire class. But it's a problem that you constantly have to manage throughout the litigation.
Also, Rule 1.5 makes it clear that where you have a contingency fee, it should be in writing. And it was not clear that, from that clip at least, that they had a written contingency fee agreement, because they're saying 40%, which is customary. If the question isn't what's customary, the question is what was in your contingency fee agreement. Note also that the amount of money the lawyers would get from that $8 million settlement was larger than the amount any one of the families would receive. That's typical and common in class action litigation. Plaintiff's attorney, the best example, modern example, is the tobacco litigation, where some law firms went away with literally multi-million-dollar settlements, hundreds of millions of dollars, as their portion of the settlement, and whereas the individual families did not get that amount of money. That doesn't mean that the lawyer's fee is unreasonable, given, and you look at factors like the complexity of the case, the difficulty of the case, etc. But sometimes, as Jim said, that creates a conflict with the families who are looking, in this case, $300,000, and the lawyer got multiple millions of dollars. But this is a good example of the lawyers bringing the settlement agreement to the client, because it's the client that has the right to accept or refuse the settlement agreement. And so the lawyers, they first are trying to persuade the client to accept it, and then they get really desperate. They say, look, we're broke. We not to put too fine a point on it, we need the money, and please accept the settlement. And that's when the lead plaintiff says, how can you tell us what it means to be in pain and to have lost everything? So now we're going to go to a clip where a lawyer does not bring a settlement to a client. This is from a movie called The Verdict. It's a great movie, by the way, on lawyer ethics, and it's fictional, whereas a civil action was not. But in all of your spare time, I would urge you to see it. One of Paul Newman's finest
I
performances.
came here to take your money. I brought snapshots to show you so I could get your money. I can't do it. I can't take it. Because if I take the money, I'm lost. I'll just be a rich ambulance chaser. I can't do it. I can't take it.
We may discuss money, Mr. Galvin. How's your law practice?
Not too good. I only got the one client.
Okay. Rule 1.2 makes it clear that this decision of whether to accept a settlement offer is the client's decision, and it's not about the lawyer. And so here we see the lawyer agonizing about his moral dilemma. What you didn't see, the settlement offer there is $210,000. And he says, I note that amount is neatly divisible by 3, and he'll get 1/3, he'll get $70,000. So that's and so he's saying, I don't want to take that $70,000 because of his moral dilemma, without reference to whether the client wants to take the other $140,000.
One of the things that happens in negotiations is that the lawyer to whom an offer has been made doesn't want to appear to be weak, which means that if you think your case is worth $1 million, then you don't want to appear that you're interested in a $220,000 settlement, but that's not your option. Your client has the right to decide whether to extinguish his or her claim for that amount of money. So what some lawyers would like the authority to do, and in some cases clients will permit them to do, is to turn down offers below a certain amount so that they can do it on the spot. That then looks like a position of strength and sends a signal that you're serious about the litigation and that they're not going to be able to buy it out from under you. But that's always an issue that again in the course of litigation you have to manage that.
Now, later in this film, the clients discover that a settlement offer has been made and that he's rejected it, and they get very angry with him, and they say, why did you do it? And they say, this is our sister who's been harmed, and that, you just can't do this. So again, in those circumstances, one of the best ways lawyers protect themselves is by full disclosure, and as Jim said, if a written agreement with the client with respect to if a settlement offer is below a certain amount, I have the authority as your agent to reject it out of hand, and that does send a message of strength to the other side. Query whether that rejections, what kind of message did that send to the other side?
Right.
Okay.
Let's see if anybody has any questions before we go on to something different. Questions, comments? Okay.
Okay.
Okay, here.
Can the client waive that right? Kind of say it's up to you as the lawyer to decide what's good and what's not?
The client can waive that right. If you, to be candid, if I were the lawyer, I would not want the waiver. I would much prefer to sit down with the client, talk about the offer, explain to the client why I thought the offer was acceptable or why I thought the offer was not acceptable. But I don't know, because the client can waive the right, and even if you have the waiver in writing, they may change their mind. And then, you're maybe litigating before a licensing board or in court as to were they unduly influenced when they made that waiver. So I think the better practice is to say to the client, no, this is your right, but let me explain why I think this offer is acceptable, or let me explain why I think this offer is not acceptable and we should go forward. Yes.
Is this dynamic any different for an in-house counsel at a corporation, where the lawyer basically is the agent of the client at all times? I'm not familiar with how that relationship works really, but.
Yeah, it's not different. The client is still the corporation, and so the lawyer doesn't speak for the corporation unless he or she's been authorized to do so. I mean, my practice was always to discuss any settlement offer with my client, even if I had authority to reject it, because sometimes what happens is that if the authority you have is based on some sum of money, the offer might include something in addition to money that makes it a much better offer. And plus, as Professor Lynk said, circumstances change, and at the time that you get the offer, you may be in a different position.
On that last point Professor Coleman made, there is a big difference, a huge difference between money, or between amounts of money that you write into a complaint. I mean, you give me a blank piece of paper, I can write any number on the paper. It means about as much as the cost of that ink. But now I write that number on a negotiable instrument, i.e. a check. All of a sudden that number means something different. So, at the beginning of the lawsuit, the client may say, we're not accepting anything less than $1 million. And then the client, the opposing party says, okay, we're willing to settle this case for $100,000. That circumstances change, and all of a sudden that's real money, and so you never want to, the more cautious approach is to always consult with the client and to advise the client, but to make sure the client is involved in that decision going forward.
Could I I'll call on you, but just one additional point. For plaintiffs' attorneys, this is also a very difficult issue at times when the lawyer has not managed the client's expectations. And so you get into a situation where for example, in employment discrimination litigation, there are reports about settlements and, with very large numbers, and clients in that type of litigation start to think of it almost like a lottery, and that if Coca-Cola paid $193 million, then we should be getting that too. And if the lawyer doesn't manage that expectation, it prevents a settlement which would be on really good terms. But
that's an excellent point, and just personal experience. In addition to being in practice, I also served as a mediator for the Superior Court in the District of Columbia. And in that capacity, you would have a lot of slip and fall cases come before the court, and a lot of attorneys who handled high volume cases. But let's say in this particular case I'm thinking of, this woman had an elevator had stopped between floors, and so the elevator stopped before the floor. She stepped out, and the floor wasn't there. She tripped and fell and broke her ankle. So they sued Otis Elevator Company and the building in which the elevator, and they sued for like $5 million. And she came in there fully expecting to get, if not $5 million, I'll settle for $2.5 million. I mean, I'm going to be generous about it. And of course, the elevator company and the building and their more importantly, their insurers had absolutely no intention of going anywhere near those numbers. And they agreed to settle the claim. They looked at her medical records. They were talking about discovery today in class. They discovered her medical records, and they agreed to pay $5,000. And she was completely distraught, and she couldn't understand how that had happened. And her attorney had not managed her expectations. And in fact, at that point, the attorney was now trying to say, well, no, pay a little more so I can collect my fee. And it got to be very sad, actually, at that point. Okay, I'm sorry.
Oh, yeah. When you're representing like a class action suit, how do you get the approval of when you have many, many clients for like a settlement?
Well, it has to be approved by the court.
Yeah, in a class action, you've got to get court approval for the fees that go to plaintiff's counsel, that go to the class counsel.
And there's a hearing. I mean, you'll learn about this in civil procedure, but there's a fairness hearing to determine whether the settlement is fair to the class.
And because you're right, I mean, the class is huge and often huge, and often, like in a civil action, they're all sitting around in a room. In most class actions, that doesn't take place, that can't take place. Okay, now we're going to look at something which I would like to think doesn't happen very often and presents issues in addition to ethical issues for counsel. This is from a verdict again. Ladies and gentlemen, U.S. postal inspectors take very poorly breaking and entering into a mailbox. That is a federal crime. And so we are sort of, the ethical rules provide that a lawyer shall not commit illegal conduct or consent to or facilitate a client's committing illegal conduct. And so one would like to think that that just doesn't happen, except in the movies. But
lawyers and law students like to be clever, and they try to think of ways that they can get something without fully disclosing what they're doing. We had a discussion in the Wrongful Convictions clinic this week about
I'm sorry, hold on.
That's okay.
Oh, goodness.
That's okay.
Well, let's... Now I think I've totally destroyed our ability to...
Very big company, Connex.
Push back a computer, I think.
Where?
Persian natural gas contract in the Persian Gulf to the Chinese. At the same time, a smaller company, Clayton, somehow gets the rights to Kazakhstan, one of the largest untapped oil fields in the world. Big company, our client merges with Clayton. Justice wants to know how Clayton got those rights. You've been scrutinizing exactly these types of deals. So if there's something to find, I expect you to get it before they do, and come straight to me. Bennett. Sir? At my firm, I have a flock of sheep who think they're lions. Maybe you're a lion everyone thinks is a sheep.
Okay, we're going to come back to that. But let's let Professor Coleman finish his remarks.
Anyway, so we had heard about an Innocence Project somewhere in the United States, where in order to get DNA samples from witnesses that they thought might have committed the crime, they would pose as testers for chewing gum companies, and they would ask the person to test various flavors of chewing gum and then let them spit it out in a little cup that they would then, the expectation would be that they would throw it away. And they would run off and take it to a laboratory to see if this is a person whose DNA was left at the crime scene. That's different than committing a federal offense. Some of our students recognize that, but they said, well, what about if we go to the person's home and we ask for some water, and we go into the kitchen and we take some glasses or something where they've used, and the point is, we said to them that you don't make misrepresentations, you don't steal, you don't jeopardize your license to practice law by engaging in that kind of conduct. If for no other reason, in addition to it being wrong, you have to think about how would you ever get this stuff into evidence? How would you explain to the court how you got it? So, even if you were able to do it, it's not likely it would be very useful to your client, and that sets back your client's interest. So.
Now, that would seem so obvious that you have to ask yourself, well, why is this even an issue? Why would any lawyer even do this? And that goes to the pressures of litigation and the pressures of being a lawyer. One of the things I know I tell my 1L students, this is a stressful profession. This is, it makes a lot of demands on you, and you want to win. And that scene from the verdict, the Paul Newman lawyer is trying to find a witness who he cannot otherwise locate. And so he's breaking into the mailbox of a nurse whom he knows is a friend of this missing nurse, this other witness, and he's getting her telephone records to track down to see if he can find out if she called this other nurse whom he knows has gone to New York City. And so that's why he's looking at telephone numbers with the 212 area code in New York City. So he is justifying what he's doing because of the urgency of his case. His case is in trial. He urgently needs to find, to find this witness. People, that's simply not a justification. It's simply not an appropriate justification. Discovery devices may be available. Subpoena in this case, he could have subpoenaed the nurse and put her under oath, and then asked her for the name of her friend and where she was located. And if she'd refused to answer, try to get a court order in that way. But you don't want to let the urgency of the moment overwhelm your longer range perspective that outside of the movies, conduct like that can only come back to bite you. I mean, it's simply for your career, it's not good, and for your client, that won't be good. You just have got to avoid it. There's really no excuse, and more importantly, no disciplinary authority or court will accept any excuse.
Lawyers do it because they get away with it. They do it because they become frustrated in trying to obtain whatever it is they're trying to obtain through the normal process. And that's when I think the temptation is greatest for lawyers, young and old, to engage in misconduct when they're trying to short-circuit something or take a shortcut because they think it's really important to get something now. That's when you've got to be most aware of the dangers that you're about to get yourself into.
Okay, now we're talking about stress, and so far we've been looking at cases involving either solo practitioners or a small law firm where the stresses are sort of obvious. You're trying to manage litigation and you're essentially on your own. You have few supports. The stresses don't get less in a large law firm practice. They may be different, but they don't get any less. And now we're going to go back to that clip, and I want you to listen carefully to what the lawyer who's the older man who's cutting the roses. He is the senior partner, managing partner in this large Washington, D.C. law firm. This is from the movie Syriana, and that law firm is representing a major oil company that is trying to get rights to an oil field in the Middle East, and these rights are contested.
Whiting, been a holiday. Very big company, Connex, our client, loses a huge natural gas contract in the Persian Gulf to the Chinese. At the same time, a smaller company, Clayton, somehow gets the rights to Kazakhstan, one of the largest untapped oil fields in the world. Big company, our client, merges with Clayton. Justice wants to know how Clayton got those rights. You've been scrutinizing exactly these types of deals. So if there's something to find, I expect you to get it before they do. And come straight to me. Bennett. Sir? At my firm, I have a flock of sheep who think they're lions. Maybe you're a lion everyone thinks is a sheep.
Well, we would all like to be lions, and in fact, in the D.C. bar, when they do retrospective memorials of the great lawyers who've practiced, they're referred to as lions of the law, and in the bar journal there's sort of little articles on the lions of the law, and obviously no one wants to be thought of as a sheep, and so. The question, though, is what does it take to be a lion, and is that always, if there is a price, is it always a price you are willing to pay or that you want to pay?
One of the, I mean, I loved practicing law, and I loved working at my law firm. It was a big law firm. It was probably like the law firm in the movie in some respects. You know, we had two of the real lions of the bar, John Pickering and Lloyd Cutler, in my firm, and they were sort of our mentors and our role model. But there's an enormous price to be paid in pursuit of that. A price in terms of your personal life. There's a price sometimes in terms of how close to the line, L-I-N-E, lawyers will go thinking that that's what it means to be a lion. And I think, you know, as in a lot of things that we've talked about, this is something that you've got to think about constantly, because it's very easy to find yourself trying to be a lion and all of a sudden you've stepped over a line and then you basically put yourself out of the business of law. But it's fun. Everybody wants to find the document that nobody else has found that wins the case for your client or protects your client's interests. And so, in that respect, it's a dog fight, and you want to be the best dog. But there's a big price that you pay sometimes for that.
And I mean, one of the ways the price is sometimes measured is in billable hours. And how many hours can you bill? 2,000 a year, 3,000? What does it do to your personal life? If you have children, do you get to see them? I remember, and everybody has stories like this. I was preparing a document that had to be in our Washington office that we had to send up to our New York office, and it had to be delivered the next day. And we were waiting either for FedEx or for some of the other. There's some other delivery services that law firms use that are even more reliable. I also wanted to leave the office and get down to a funeral service in Virginia, where a relative of mine, funeral was taking place. And theoretically, I could have left the office and left this document with my secretary for it to be picked up and delivered. But I decided not to, because this was absolutely something that had to take place. And if FedEx didn't come in time, we had to go to DHL, or we had to go to whatever. But it absolutely, I was an associate at the time, and so when the partner called me and said, as he would, Myles, did this go, was it picked up? I needed to be able to say, from my own personal knowledge, this document was picked up and it's going to be delivered at X hour the next day. So I had to wait, and I waited. Finally, they came, got the document signed off, and I was late for the funeral. I didn't get there in time for the funeral. That's just, in a very small way, sort of the kind of sacrifices you're going to make in a service profession. You are in a service profession. You're providing services to others. Not only your clients depend on you, but your partners in your law firm depend on you. Other people depend on you. And sometimes those professional obligations do conflict with personal obligations. And that's simply something, as physicians have to think about it, so do you have to think about it. That's simply one of the prices or one of the costs you're going to pay to make sure that you're responsible to your professional duties. All right, now, in the next clip, we're going to see a lawyer who is a lion, but for whom being a lion, the stresses get a little too much. This is from another George Clooney movie. It's called Michael Clayton, and it's another movie I strongly recommend for many ethical issues. We're going to look at just this one.
Well, that's what happens to a lion when he's been in the fight too long.
A lion in winter.
A lion in winter, deep winter. This is what you want to avoid, obviously. I think what you don't hear in this clip is that what Clayton says to him is that you need to stay on your meds. He had gone off his meds, and this is kind of what happened. Yeah, go ahead.
Rule 5.1 says that partners and managers, supervisors of lawyers have a responsibility to each other to make sure that all the lawyers in the firm are aware of the rules of ethics and comply with the rules of ethics. Now, how this lawyer has acted, one question is his mental capacity, and clearly it would appear he is no longer capable of effectively representing this client. And it's also clear that he is the senior-most partner on this account, and the firm has really not had another partner overlook him. Michael Clayton is not a partner in this film, and the other lawyers who are at this deposition in Milwaukee are all associates, and very relatively junior associates at that. So after the fact, there's a real scramble to try to undo the damage that he has done. There's another clip here where he takes a very confidential client document, and he discusses it. He knows his phone is tapped, so he discloses the confidential material in this document to the people who are tapping his phone. He doesn't know who they are. It's a very difficult situation for law firms to deal with, and it happens. Substance abuse among lawyers as a result, as a way to sort of deal with tension and stress, happens. How firms manage that and how they manage the fallout so that the client's interests are not harmed is a very, very important and sometimes it can be a very difficult situation. In fact, this whole movie is about the difficulty the firm has in managing this lawyer's breakdown.
Yeah, one of the things that and this is understandable in big law firms, people try to protect each other in a way that doesn't actually protect them. That is that, lawyers are aware that some of their partners or some of the associates are engaging in self-destructive behavior, but they don't want to tell on them because, they don't talk to them about it. They don't want to tell others that it's going on because they don't want to get them into trouble. And that's probably the worst thing that I think you can do as a lawyer is to not deal with a situation that's obvious to you that somebody is engaging in self-destructive behavior. You protect your firm, you protect your clients, you protect the individual, I think, when you deal honestly with these kinds of problems. But you'll see a lot of you are going to end up in law firms or other places where people under a lot of stress are going to, try to find escapes from it, and some of those escapes are going to be very destructive, and you're going to be in a position to do something about it, and you're going to have to make a decision whether to intervene or to just simply hope that things work out. My advice always is to intervene, to try to help.
All right, now the next clip, I think the last one we'll be able to do, deals with this disclosure of the confidential document, and it's really about a conflicts of interest, and that is a big issue for lawyers at all levels of practice, and this sort of sets it up here. Again, I apologize for language. Just a note on the female character, that's Tilda Swinton. She won an Academy Award as Best Supporting Actress for her role as the General Counsel of United Northfield in this movie. One of the most interesting aspects of her character is how isolated she is. And although she's been handpicked by the company's CEO for this job, in part, it appears, because he wants a woman General Counsel, she has no one to turn to help her through this dilemma, and she ends up turning to these guys who are who engage in extreme measures. Let's just leave it at that. And that isolation is simply something you want to avoid at all costs. And if you're in a firm and one of your clients is a general counsel, you always want to make sure that they are either have you to talk to or someone else. But isolation can be deadly, because you often take positions, make decisions in a vacuum without someone to give you a reality check, and she does that here. This clip is an example of a conflict of interest. The lawyer, played by Wilkinson, has become infatuated with the lead plaintiff in a class action lawsuit brought against U North for this product. The lead plaintiff, by the way, is played by Anna Paquin, the lead in True Blood. This was her last role as sort of an ingenue before she graduated to Femme Fatale. But it's and so he now is totally hostile to his company and to the company's product, which he is defending, and his hostility is made manifest in that rant.
The other issue that it deals with is confidentiality, which, as a lawyer is a really important doctrine, protects your client's confidences, secrets, information about your client. We had a case here in North Carolina where a lawyer, the head of the appellate public defender, had a client who confessed to him that he had committed a murder for which another man had been convicted and sentenced to death. And when the client died, Staples Hughes is his name. Staples Hughes is the lawyer, tried to disclose to the court in a case involving the person sentenced to death that his client had made this confession. The court refused to hear it and referred him to the bar for being willing to make the disclosure. This is a very serious thing. It puts you in a situation where you may know some information either about the lawsuit in which you are defending or about some other matter where the information would make a big difference, and you are silenced by the attorney-client privilege. I think lawyers get used to that, and it's something you have to deal with. But again, it's one of those things that in some circumstances will challenge you because you think that the right thing to do may be to make the disclosure.
Well, Professor Coleman's point is an excellent point, and it is a critical point to the sort of moral universe in which lawyers operate. There are certain points of contact in that universe where you operate in a parallel but somewhat different manner from other people. And the most sort of egregious example of that is client confidentiality. You may know information which would be of benefit to someone else, as in the example given, but if that you don't have the right to violate your client's confidence. You don't have the right to disclose that information. Your client may disclose it if they so choose, but that's not your right to do so. We were talking about that in class today. Who has that privilege? It's the client's privilege. It's the attorney is bound by that privilege, and the need to keep confidential information is huge. In the example in the film, what that attorney should do is if he feels so conflicted about representing the client, remove himself from the representation. Although he may be the senior litigator in the firm, there are presumably many other litigators in the firm who would be delighted to step in to that representation. But he does not have the option of disclosing confidential client information to other people, particularly when that information will then be used against his client. That simply is not a viable option, and it's not something that he should engage in.
Any questions, comments?
One of the other things about practicing law is that you get to do a lot of unique and different things. And although we were at different law firms, Professor Coleman and I did jointly have a matter that we worked on together involving I think it's fair to say it was a pro bono matter, involving a Senate staffer who was being investigated for some impropriety or some alleged impropriety, and that opportunity to sort of engage in sort of areas outside of the four corners, either of transactional practice or litigation, is something you find certainly in Washington, D.C., but I would suspect in many other jurisdictions. I mean, lawyers have the capacity. Often you're called upon to advise a local municipality or a school board or a state, or again, in this case, the Congress. And so those are some of the exciting possibilities and sort of some of the exciting options that are available to you or that will be available to you in a few years.
I think it's very difficult at times working at a big law firm. It's very demanding. It sometimes it makes you choose between your personal interests, your personal life, and some client, maybe about whom you don't really care a great deal, but that's demanding that you do a lot of work. But I loved almost every minute of it, not every minute of it. Sometimes the work that I did, it would have been the last thing on earth I would have elected to do if I had a choice. But in the long run, I think being a lawyer is something that is really important. At times, it can be noble, and I think all of you have, and I hope that all of you will have an opportunity over the course of your career to do some of the noble things that lawyers do, in addition to some of the things that are going to challenge you and that are going to wear you down. But I think, on balance, when you look back on it, I think it's really worth it. But you've got to be careful, because it's very easy to get yourself into trouble by trying to be too much of a lion and sort of taking the fight to places where you shouldn't go.
Any questions? Yes.
How do you deal with the pressures to be unethical from authority? So like in a law firm environment, what if the senior partner asks you to do something very specific, which you know to be unethical, and you have a problem with it, but then again, he's also your boss?
Well, generally, in the normal course of events, the senior partner in a large law firm is not, and in your hypothetical, you're a young associate, is not going to ask you to do something unethical. It's not going to be that obvious. It's not going to be that sort of black and white. You may be interacting with a more senior associate who's acting with a junior partner who's talking to the senior partner. There's a case involving Baker & Botts, a law firm in Texas, and this involved their D.C. office. And a lawyer there who was a partner felt that another partner in the firm was overbilling, was unethically overbilling one of their oil firm clients. And she took it, and she felt, since she had to prepare the bills, that was improper. She took it to the senior partner and complained about it, and made lots of noises about it, and ultimately they discussed it with the client. The client felt that there was no impropriety, that the bill was fine, and she was fired. And she ultimately brought suit against the firm, and she lost on the theory that as a partnership's a voluntary association, and they decided to end that association with her. Now, when you look back on that situation, there are ways you can do things. I mean, if in fact you're in a situation where you are affirmatively asked to do something that you believe is unethical, you should discuss it with someone. Discuss it with the person who asked you and explain why you think it's unethical, or discuss it with someone else if you have a mentor or a partner with whom you usually work, and why you have problems with it, and sort of sort through it. One of the things I say to lawyers, that license that is on the wall in your office is specific to you. The firm didn't give you that license, and when you leave, the license will go with you. So your ultimate responsibility in terms of your adherence to the ethical rules is a responsibility to you and to your clients. And ultimately, you may decide, because this does violate the rules, I can't do it. But you don't want to make, if that's where you're going, you want to make a record of why you think it's unethical. You want to make sure you have discussed it with others, you've heard other views, and you may have to make that decision, understanding that that decision has consequences. They often say virtue is its own reward, and I think what they mean by that is it may be expensive to be virtuous. And in her case, she lost her job. That could happen. I mean, that happens. And if they disagree with you, but you may feel, on the other hand, what else could, it could be just the opposite. That they could say, you know what, we didn't see this as you see it. You've raised a very good issue, and thank you. Thank you for raising it, and now we're going to go to Plan B, because we don't want to go to Plan A, and you have, in that instance, vindicated their decision to hire you. So, but obviously proceed with care.
I agree with that completely. You have to protect your own reputation, but you don't want to sort of shoot from the hip because often, particularly young lawyers, don't know all of the facts, and so it's not always easy to know when you've been asked to do something that's wrong. That's not to say that you don't sometimes get asked to do things that might be wrong or that you personally might find wrong, but you have to be careful. And I think the best advice that Professor Lynk gave to all of you is to make sure you don't become isolated wherever you work, in a law firm or wherever you're working. You want to work with people with whom you can have discussions about these kinds of issues. You want to find somebody in your firm, if that's where you are, whose advice you value and with whom you can have a discussion about these kinds of things. That's really important. You don't want to make decisions that based solely on what you know and kind of how you interpret situations, because sometimes you're wrong and you create a lot of problems for the firm and for yourself when you sort of act on the basis of incomplete information. And confidential documents.
All right.
Any other questions, comments?
I think we have time for one more. Yes.
I guess since these are generic examples, do either of you have specific examples of a time in practice where you felt ethically challenged, and what was it, and how'd you deal with it?
Where I personally felt ethically challenged, no, I never did. I mean, and that's honest. I worked at one of the things you'll also find is that these big law firms tend to be very ethical because they can't afford not to be. It's very dangerous when you sort of start to, cut corners and try to evade the rules. So in my firm, we had, as I mentioned, John Pickering and Lloyd Cutler, who are our two senior partners. They set a standard that the rest of us, tried to live up to, and it was, to always be ethical. So I've never, in any job that I've had, I've never been in a situation where I thought I was being asked to do something that was unethical.
Yeah, I would agree with that, and it's interesting when you asked the question, we both had to really sort of struggle to think about it, because again, in a large firm, well, Professor Coleman said, I mean, there's simply too much at stake, and there are layers. Most firms, for example, have ethics committees. When you take in a new matter, a new client, one of the first things you do is run it through a conflicts check to see if there are any conflicts of interest with existing clients. And if there are, then there's a discussion about whether we can take on this new client or whether the existing client will waive the conflict that might arise. But I cannot honestly say that I can recall a specific matter where I felt I was being asked to do something unethical. I would say the most common ethical issue in large firms are conflicts of interest between existing clients. Not like in that case where the lawyer for one side gets infatuated with somebody on the other side, but where you're representing two clients, and they may be at odds in some other matter or something. And the firm has to decide how to proceed with respect to both of those clients. So that's sort of a generic answer. I mean, I think for large firms, that's sort of the most common conflict situation that sometimes comes up. But in terms of me specifically, I have to say I can't think of a specific example, thankfully.
And I think when you get out in practice, those of you who go to large firms, I think you'll find also that you're not going to be put in situations where people are asking you to do things that you think are unethical. People are going to be asking you to do things that you think may be physically impossible, but that's a different problem.
But again, most ethical dilemmas when they arise are not black and white. They are shades of gray, and one of the challenges, one of the challenges for lawyers is, and for all professionals, you could argue for all people, is to prospectively anticipate or to look at something that's come before you and to be able to analyze it and say, you know what, there are potential problems here, and I've got to proceed carefully. Look at, Enron and the lawyers who approved the special purpose entities that allowed Enron to park their debts in these companies that were actually related, although on the books they looked like they were unrelated. The lawyers blessed that, and in retrospect, they shouldn't have. And how do you, you have to approach each issue that arises with a view that it could provide tremendous opportunities, a new client, a new matter, an opportunity for a new experience, billable hours, but it could also represent problems, and I need to guard against that. I need to be aware of what they might be, and I need to proceed carefully in all matters. I would say that would be the sort of long-term advice I would give.
Edward Bennett Williams, who was the named partner in Williams and Connolly, used to tell his lawyers, they did criminal defense work, white-collar criminal defense work, but he used to tell his young lawyers to make sure at the end of a case that if anybody went to jail, it was the client. And I think that's good advice, and on sort of thinking about it in terms of ethics, the point is that if your client has an ethical problem, you don't want to make it your personal ethical